Every broker has to have an office somewhere. It does not have to be in the state of Florida. And an office is defined as at least one enclosed room of stationary construction where negotiations take place and records are kept. Sales associates cannot have an official office. They can work out of their house, obviously, but they cannot have an official office. The broker has to have on or about the entrance of that office certain information. It's called an official sign. It has to have the broker's name or the brokerage entity and the words licensed real estate broker. An example might be Wilderness Realty Incorporated, David Crockett, licensed real estate broker. Some of those things can be, or some of those words can be abbreviated, like the words incorporated or licensed, but by and large, everything has to be spelled out. The sign does not have to be on the exterior, but it has to be readily visible to anybody entering the building. Now, as far as a branch office is concerned, I want to make sure we know the difference between a branch office and a temporary shelter. A branch office is an additional office to the main office. Remember earlier we said that the broker's main office, if they move it from one location to the next, they have to notify the division of real estate within 10 days of that move. Branch offices function the very same way, but branch offices are not transferable, which means that if you go from one branch office to another, all you're doing is reopening and getting a new registration for every new branch office that you open. The rules all apply. There has to be the broker's official sign out front where negotiations take place and records are kept. At least one enclosed room of stationary construction where negotiations take place and records are kept. Now, as far as the licensing period for a branch office or any office, it's for 2 years. So once a branch office is registered with the Division of Real Estate, it's going to be there for 2 years, whether you come and go or whether you're there or not. As far as a temporary shelter is concerned, a temporary shelter is a place where the public does not perceive it to be an office. It could be a tent where people are getting out of the weather at maybe an open house of some kind or a development project. It could be a construction trailer where most of the activity there is for construction workers and not for real estate. If the public thinks it's an office, it is. Let me give an example. You can set open houses, you can set model homes, and if it's decorated like a model home, it doesn't have to be registered as long as it's not permanent. But once you establish either a bedroom or the garage into a permanent office and the public perceives it to be an office, then that has to be registered with the division as a branch office. Regarding advertising, every broker is going to be fully responsible for all ads run in that office. And the broker is going to be, they're in total control. Let's talk about a blind ad. The minimum requirement for any print media advertisement is going to be the name of the brokerage entity. So in other words, if it's ABC Realty, that has to be in every print media ad. That includes business cards, find-a-home magazines, newspapers, things of that nature. Anytime that you're dealing with the internet, we call that the point of contact information. That requirement is expanded to not only include the name of the brokerage entity, but also telephone numbers, addresses, and email addresses. So the point of contact expands the concept of the blind ad. Let's talk about cold calling. There are government limitations on individuals who cold call. Obviously, there are lists that are out there. Currently, there are 2 lists that we have to be aware of. There is the U.S. government's do not call list, and there's the state of Florida do not call list. In either case, they've got rules set up for it. If we're talking about the Florida do not call list, what it's basically saying is that anybody that has applied and that's on that do not call list, we're prohibited from calling, provided that we've not done business with them over the last 18 months. And when I talk about business, I'm not talking about just telephone calls. I'm talking about physical business. As far as the federal rule is concerned, as long as we've done business with them in the last 90 days, we can call them. Otherwise, we're prohibited. But let me tell you the most important part about this. When we're talking about for sale by owners, when we're talking about FSBOs and cold calling FSBOs, The state of Florida says that if someone advertises their telephone number for you to call, then they no longer qualify to be on the state do not call list. The federal government doesn't see it that way. If they're on that list, they're on that list regardless if they advertise for you to call or not. So I think the real do not call list that you need to look for, if you're calling for sale by owners, you need to look at that federal or U.S. do not call list. If they're on there, simply don't call. Regarding handling deposits and escrow, let me make a comment about earnest money deposits and escrow. In most of your contractual situations, earnest money is not required by law to create a contract. We typically take escrow money or earnest money to show good faith on the buyer's side or the tenant side, and also use that if the buyer breaches as liquidated damages. As far as where we can keep, a broker does not have to have an escrow account. But for those brokers who choose to hold escrow, it has to be in the state of Florida, or it has to be doing business in the state of Florida. And there are a number of places that we can hold escrow. Commercial banks, savings and loans, and credit unions are three of the basic places that we hold escrow if a broker decides to. Brokers can also turn over escrow or earnest money to either title companies or an attorney. Now, there's a little bit of a difference in the way that we handle, because once we turn money over to a title company or an attorney, then that relieves a lot of responsibility from the broker in case there are disputes and things of that nature. A broker who's opening up a sales account for sales can't commingle or cannot convert money. We are allowed to put in up to $1,000 to open up a sales account, and we're allowed to put in up to $5,000 of our own personal money to open up a property management account. Also, it's worthwhile noting that if a broker has both a sales department and a property management department, the law doesn't say that they have to have two different accounts. They can actually have one account that holds both. The bottom line is that we usually separate it just for safekeeping, just to make sure we don't confuse things. Now, as far as what can we accept, we can accept cash, we can accept checks, we can accept jewelry, stocks and bonds. Those are some of the things that we typically will collect and put in escrow, but it doesn't have to be that. It could be anything of value. And by the way, escrow simply means a place of safekeeping. It doesn't have to be an account. For instance, if you were to take jewelry as earnest money, you can place that in a safety deposit box or some place of safekeeping, as long as the buyer and seller know about it and agree to it. As far as immediate and placing money into escrow, I think it's important that you know that for a sales associate, that money has to be placed or turned over to your broker within 1 business day of collecting that escrow. Brokers have a responsibility of delivering that into escrow within 3 business days of that collection. And just for clarification, that time period starts the same for both. In other words, it's the date that the salesperson collects it, the meter starts to run for both of them. An easy way to remember this and an easy way to view this is that the way the Department of Business Professional Regulation audits, they come in and they want to see the broker's contracts. They look at the front and they look at where the deposit was made as part of the offer. They turn it over to the back and see when the buyer made the offer. They look at the date next to it. That's when the meter starts to run for both. It's when that offer was made and what the contract says that that deposit was delivered. So immediate means 1 business day for sales associates, 3 business days for brokers. Remember that weekends, Saturday and Sunday are excluded, and any national holiday is also excluded. As far as conflicting demands are concerned, we don't like these, but sometimes brokers and sales associates have to deal with buyers and sellers that can't agree in the contract, and all of a sudden we have conflicting demands over the contract, and the next thing you know, we have a dispute over the deposit. Anytime that a broker has conflicting demands, that is both the buyer and the seller making a demand on the deposit, there are a couple things that have to be done. First, if it's the broker who's holding escrow, not a title company or not an attorney, but when the broker is holding escrow, they've got to notify the Florida Real Estate Commission within 15 business days of the last demand on that escrow money. If that is not resolved within a grand total of 30 business days of the last demand, then the broker is going to have to take one of four procedures. Typically speaking, it's going to either go to mediation. Mediation is where you're having a third party that's going to sit in and help negotiate it. It's a non-binding situation. It can go to arbitration, where you have that third party sitting in, listening and making the decision for you. That is typically binding. The parties can also litigate, and that is they can take it to court and sue each other and let a judge make that determination. But finally, what a lot of brokers do today is, if they're holding escrow, they turn it over to the Florida Real Estate Commission and ask the commission to give them a ruling. That's called an escrow disbursement order. And whatever the commission says, that broker has to abide by. So those are the four ways that we can resolve disputes. Also, let me make a comment about that once we file with the DBPR or with the Florida Real Estate Commission that we have escrow problems, if we somehow get it resolved before they make a decision, make sure that the DBPR and the Florida Real Estate Commission are notified within 10 days of that resolution. Otherwise, those books are still open, and that could cause the broker some problems. Also, let me make a comment about good faith doubt. Good faith doubt is not conflicting demands yet, but there's a situation that has arisen that could create that could create conflicting demands at a later date, where things are not settled. For instance, if you go beyond a closing without a written extension, that could be considered to be good faith doubt. Regarding rental information, brokers in the state of Florida are allowed to sell rental information lists. In other words, what they've done is they've collected a number of rental properties in the marketplace, and they sell these lists to potential tenants. The rule is this, it's real easy. If the list is correct and the tenant simply decides not to rent, that broker has to be prepared to pay back 75% of what was paid for that list. If the list was inaccurate materially, the broker has to be prepared to pay back 100% of what that person paid for the list. And here's the catch. That demand on the refund has to be made within 30 days of buying that list. If the broker does not have the money to pay back, according to Florida law, that's considered to be a misdemeanor of the first degree, which could carry a penalty of up to at least 1 year, up to 1 year in a county jail, and or up to $1,000 fine. As far as commissions are concerned, I think it's important to note that a sales associate can only be paid by their employer and nobody else. In fact, a sales associate cannot be paid by another sales associate in the same office. Brokers have to cut separate checks. As far as price fixing is concerned, violation of the Sherman-Clayton antitrust law is going to be illegal, and that's where two or more brokers get together and set commissions in a particular market. As far as changing employers, we talked about that a little earlier. Just remember that if you decide to change employers, that your new employer has to notify the Division of Real Estate within 10 days of that move. If that's not done, remember that your license will cease to be in force. Also, we talked about changing addresses. Let me make a comment about unauthorized display of names or insignias, which has been tested quite a bit. If a broker is was a member of the Realtor organization, remember that Realtor is a trade name for a trade organization. You don't get a license to become a Realtor. You get a real estate license and you join as a member of the Florida Association of Realtors or whatever your local association is. If that broker is no longer in good standing with the National Association of Realtors, the Florida Association, or your local association, they can no longer use the Realtor emblems or insignias. You got to take them down. It's illegal if you do that. As far as the different types of brokerage entities that are available right now for brokerage to have, probably one of the more common is the sole proprietorship. The sole proprietorship is an individual broker that goes into business for his or herself. They're able to hire sales associates. It's important to know that that broker is going to be fully responsible personally for that business entity. The general partnership, on the other hand, is going to be a situation or relationship between two or more individuals that have gone into business for either profit or nonprofit, depending on how you look at it. At least one of the partners has to be a licensed real estate broker. Has to be. I think the important issues here with the general partnership, two of them actually. One is the general partnership is the only multiple owned business entity that does not have to be in writing and doesn't have to be filed with the Department of State. It can actually be by handshake. But remember that if it's a general partnership and it's a verbal agreement, that all the partners are equally liable for each other's actions as it relates to the business. Also, I think that it's important to note that as general partners, sales associates and broker associates cannot be general partners, period. They can work for the partnership, but they cannot act as general partners. As far as an ostensible partnership is concerned, this is a partnership out of circumstance and not choice. In other words, if it's perceived that two brokers are in partnership together, they may be construed as ostensible partners. A good example might be that I have my office opened, I've got my sign on or about the entrance like I'm supposed to. Another broker moves in next door to me and doesn't put a sign up. The public may perceive us to be partners, therefore I may be responsible for that person's actions. As far as a corporation is concerned, we form a corporation by filing with the Department of State. It's owned by stockholders. Stockholders will elect a board of directors, and that board of directors will appoint officers. Officers include the president, the vice president, etc. It's interesting to note and that you need to remember that as far as officers are concerned, it's got to be at least one active broker who's an officer. Sales associates and broker associates cannot be officers or directors of a real estate brokerage corporation. Now, sales associates or broker associates can own stock. In fact, they can own all the stock, but they cannot be officers or directors. As far as limited partnerships are concerned, a limited partnership is made up of one or more general partner and one or more limited partners. Once again, as general partners, sales associates or broker associates cannot be general partners. However, by the nature of the way it's formed, sales associates and broker associates can be limited partners. Remember that all a limited partner is somebody that puts up and shuts up. They are kind of like stockholders, if you will. As far as trade names are concerned, from a test standpoint, remember only brokers can operate under a trade or fictitious name. David L. Collins, doing business as ABC Realty. Sales associates cannot operate in any other name other than the name that you're licensed under. And the minimum requirement for any sales associate when they're advertising is going to be their last name as they're licensed. Also, as far as business entities are concerned, a sales associate or broker associate can create a business entity to function under, but they're very limited. They can do a PC, an LLC, or a PLLC. Those are the only three that you're allowed to do. And speaking of business entities, who can broker real estate? To begin with, we know that a corporation sole cannot. A corporation sole is going to be a church. They can own real estate, but they cannot broker for others. A joint venture is when two or more people get together for a single project. They can do it for themselves, but they can't broker for other people. Business trusts, cooperative associations, and unincorporated associations cannot broker real estate. That's the end of that chapter. So now what I'd like to do is do the review for you. Every broker must have an office somewhere. It doesn't have to be in the state of Florida, by the way. It can be anywhere in the world. Required information for the official sign, it's got to have the broker or the brokerage entity and the words licensed real estate broker. Now, a broker can put sales associates or broker associates' name on the official sign, but it has to be segregated from the brokers and their license status next to them. Branch offices are not transferable, and the registrations, remember, are good for 2 years. Construction trailers are considered to be temporary shelter. The broker is ultimately responsible for all advertising. Ads without the brokerage name in there is considered to be a blind ad. The federal no solicitation prohibits cold calling FSBOs. Immediate means 3 business days to deliver to escrow for earnest money for brokers and 1 business day for sales associates to get to their broker. The settlement procedures and conflicting demands rules are, first of all, mediation, arbitration, litigation, and escrow disbursement. That's how we settle these disputes. Also remember that if the issue was resolved prior to some type of ruling by FREC, they need to be notified within 10 days of that resolution. Rental information list. If the information is correct, remember that the broker has to be prepared to pay back 75% of what was paid. If the information was materially incorrect, the broker has to be prepared to pay back 100% of what was paid. But the demand for the refund has to be made within 30 days of buying the list. General partnerships are made up of 2 or more persons, at least 1 active broker. Associates cannot be general partners. Corporations, at least 1 active broker. Associates cannot be officers or directors, but they can be stockholders. And remember that associates can also be limited partners in a limited partnership. And this is the end of this chapter's review.